Good morning, everyone, and welcome to our webinar looking at recent developments in professional regulatory and disciplinary law. My name is Catherine Allen, and I'm head of the Public Regulatory and Investigations team here in Mason Hayes and Curran. We are hosting this webinar in conjunction with the Professional Regulatory and Disciplinary Bar Association of Ireland, which is a specialist bar association for barristers who practice before professional regulatory tribunals and who are interested in professional regulatory and disciplinary law. I'm joined this morning by Louise Beirne, Maurice Osborne, and my colleague Kate Hogan. More on them in a moment, but just to say that each of their presentations will last around 15 minutes, and there will be an opportunity for Q&A at the end. So I'm sure you're all used to webinars now and the Q&A function. So if you'd like to pop your Q&A or your Qs rather, as they occur to you during the session, and we will try and reach as many of them as we can at the very end. So turning then to our speakers, Louise Beirne is a practicing barrister and she specialises in professional regulatory law and also in statutory interpretation. And over the years, she has represented both regulators and registrants. And her topic this morning is going to be disciplinary complaints arising out of COVID-19. And Louise has very kindly prepared a paper on the topic, which will be circulated after this morning's event. Maurice Osborne is also a practicing barrister. He has a general civil practice, but he does specialise in regulatory and disciplinary law also. And he's appeared before all tribunals, including regulatory bodies. He's a committee member of the Professional Regulatory and Disciplinary Bar Association, and he frequently publishes and presents in the area. And Maurice is going to talk to us this morning about the Regulated Professions Health and Social Care Amendment Act 2020. And again, Maurice has very kindly prepared a paper, and that will also be circulated after the event. And finally, Kate Hogan is a senior associate here in our professional regulatory practice in Mason Hayes and Curran. And as you might expect, Kate regularly advises professional disciplinary bodies on investigations and fitness to practice inquiries. And she has extensive experience in advising public and healthcare bodies on a broad range of litigation and advisory matters. And Kate's topic this morning is professional disciplinary proceedings and the rule against double jeopardy. So on that note, I'd like to hand over to Kate. Thank you.
Thank you, Catherine, and welcome everyone to the webinar this morning. As Catherine set out, my topic this morning is professional disciplinary proceedings and the rule against double jeopardy. So to begin with, I suppose some people might be familiar with the concept of double jeopardy from the film of the same name, starring Ashley Judd, where her character was framed by her husband for murder. And following her release from prison, she sets out to kill him, assuming that no court can convict her for the same crime again. But you might be surprised, or not surprised here, that that is not how the rule against double jeopardy works in practice. In a legal context, the rule against double jeopardy provides that where a person is fairly found not guilty upon any indictment or other prosecution, they may plead to such acquittal in any subsequent accusation for the same crime. In the context of proceedings, this rule prohibits reopening an issue which has already been decided between the parties concerned by a competent court or tribunal. In the context of disciplinary proceedings, registrants have tried to have disciplinary proceedings stayed following acquittal of a criminal charge on the basis that such proceedings would offend the rule against double jeopardy or res judicata, or would be fundamentally unfair and oppressive. A recent High Court challenge brought by Dr. Samuel Van Eden against the Medical Council has brought this issue to light recently. In this presentation, I will explore the approach taken by the courts in Ireland and in England and Wales to the rule against double jeopardy in the context of professional disciplinary proceedings. And I will provide a short update in relation to the recent challenge brought by Dr. Van Eden. So the rule against double jeopardy has not been accepted by the courts in either Ireland or in England and Wales as a reason not to proceed with disciplinary proceedings following an acquittal. The case law to date has made a definite distinction between the aims and objectives of the criminal and regulatory proceedings. This was enunciated by Lord Diplock in the case of Zitterman and the GDC, where he set out that the purpose of disciplinary proceedings against a person who has been convicted of a criminal offence is not to punish him a second time for the same offence, but to protect the public who may come to him and to maintain the high standards and good reputation of an honourable profession. However, there has been a different approach taken by the courts in Ireland in terms of what can be alleged by the regulator following an acquittal. And the key case setting out the approach by the Irish courts in relation to the rule against double jeopardy in the context of disciplinary proceedings is the case of AA and the Medical Council. In this case, the registrant AA was accused of sexual assault. The allegation was based on him carrying out intimate examinations by way of pre-operative assessment on female patients undergoing routine surgery. He was acquitted of the criminal charges, but following acquittal, he faced professional disciplinary proceedings before the Fitness to Practice Committee. The allegations before the committee related to examinations of the same two women who were the subject of the criminal charges. In particular, the first two allegations on the notice of inquiry specifically accused the doctor of assault and/or indecent assault and sexual assault. AA challenged the right of the Medical Council to hold an inquiry and argued that the regulatory proceedings would offend the rule against double jeopardy, and that having been acquitted of the charges of sexual assault before a judge and jury, he should not be expected to defend himself against the same charges before the Fitness to Practice Committee. Mr. Justice O'Keefe distinguished the purpose of professional disciplinary proceedings and criminal proceedings in his judgment, and he set out that the purpose of the contemplated proceedings in this case was not primarily punitive, but was one to ensure that no person unfit because of his conduct should be allowed to continue to practice the particular profession or calling enjoyed by the applicant. However, Mr. Justice O'Keefe did say that it would be essentially unfair were the respondent to enter upon a hearing to determine that the applicant was guilty of an assault of which he had been in court. He therefore set out that it was unfair if the registrant was dealing with allegations which was exactly the same as the charge he was acquitted of during the criminal proceedings. And as a result of this, the Fitness to Practice Committee were prohibited from holding an inquiry in relation to the allegations that AA committed an assault or a sexual assault. The other allegations relating to the underlying conduct, so these included inappropriate. Another key case in Ireland in relation to the approach of the courts to the rule against double jeopardy
Good morning. I'm sorry, we seem to be having a little difficulty with Kate's sound there. We might just hand over to Louise if that's all right, and hopefully pick up on the rest of Kate's presentation later on. Louise, could I ask you to take over from this point?
Absolutely. As we all know, there's only one law we can count on, and that is Murphy's Law. So thank you for having me to speak today. I'm going to talk to you about disciplinary complaints arising out of COVID. And for me, there's two sides to that coin. There's the question of how complaints arising during the pandemic should be dealt with by the regulator. And there's also attitudes to COVID, particularly COVID denial and opposition to vaccines, as grounds for complaint. And I'm going to address each of those issues in turn. And in so doing, I want to look at the well-established principles of professional regulatory law when I look at those issues. And finally, I want to name what I consider to be a particular challenge for regulators in the times that we are living. So, at the outset, we have to acknowledge that, to quote Churchill, never before has so much been owed by so many to so few. And having regard to the extraordinary burden that the pandemic has placed on healthcare professionals, it is worth noting that at the beginning of the pandemic, several US states brought in legislation conferring immunity on healthcare practitioners against certain civil and criminal claims. But this did not include complaints to the regulator. Following the introduction of emergency immunity legislation in New York State, there were calls for similar legislation here. Also, the Medical Council was asked to reassure doctors that they wouldn't be subjected to complaints following decisions made by them in good faith during the crisis. In a statement published on its website, the Medical Council indicated that it would consider complaints against individual practitioners in the context in which they were working. And however, it is also clear from that statement that the pandemic will not be accepted as a carte blanche defense. That statement advises doctors to follow clinical guidelines as well as the Guide to Professional Conduct and Ethics insofar as possible, to exercise clinical judgment, to recognize areas of practice where they are not proficient without consultation with colleagues, and to practice self-care. Now, there are no great surprises there. As with any case where the question of whether a practitioner has met the expected standards arises, his or her practice has to be judged in the context in which they're working, particularly the level of resources and supports available to them. And as we all know, the fact that there are systems failures does not necessarily mean that a practitioner will have a sustainable defense. So, moving on from complaints that happen to occur during COVID to COVID as a grounds of complaints, it is worth noting. Number one, the Medical Council has written to a number of practitioners reminding them of their ethical duties in relation to COVID. Number two, as of March, there were a number of Medical Council investigations underway in respect of individual practitioners' handling of COVID. And in terms of guidance of how these cases may be dealt with if they come to an inquiry, it's useful to look at the judgment of Ms. Justice Irvine in the case of the Medical Council and Waters, and the decision of the Nursing and Midwifery Council in the Shemarani case. So let's look at Waters first. That's a written judgment arising out of an application by the Medical Council to suspend a GP's registration pending an inquiry into his fitness to practice. A number of facts were not disputed in that case. No masks were worn by the doctor or his staff. The wearing of masks by patients was not encouraged or enforced. He operated a walk-in appointment system, contrary to public health guidelines. No physical distancing measures were in place. He never referred any patient for a COVID test, and he had made clear that he would not be administering the vaccine. one of the key planks of the doctor's defence when the matter came before the High Court was that he was a conscientious objector. And the Medical Council accepted that he was entitled to hold personal and professional views. However, it stated that it was concerned for the safety of his patients on the basis that his views were based on third-party material which could not be objectively verified and included conspiracy-type theories that range from medical to economic theories. Moreover, the council was concerned that the doctor was undermining the public health message with comments that he sees it as his duty to make to his patients. And they were also concerned that the way he ran his practice created unacceptable risks in terms of the spread of COVID. Now, Ms. Justice Irvine was in no doubt that should his conduct indeed be protected by his right to conscientiously object, he could not be suspended for exercising that right. However, she indicated her view that it was unlikely that any conduct on his part other than that which related to his willingness to administer vaccines would be protected on that basis. She went on to say that even if his view in relation to vaccines could benefit from that protection, it would be very difficult for him to defend his conduct on the basis that he had not complied with paragraph 49 of the code, which provides protection for conscientious objectors. In that regard, she noted he hadn't taken or didn't appear to have taken any of the requisite steps to inform his patients as soon as possible of his objection or of their right to have the vaccine administered by another doctor as required by the code. Leaving aside the vaccine issue, Ms. Justice Irvine found that there were nonetheless omissions which the doctor would find difficult to defend on the basis of conscientious objection or indeed any other basis. And in that regard, she found that he hadn't denied that COVID could kill, was contagious, or that its onwards transmission was prevented by testing and tracing, or by getting people who were infected to self-isolate and physically distance. She further stated that it was hard to see how his rights to conscientious objection could entitle him to make decisions for his patients regarding the risks they should be willing to accept when visiting his practice. And having regard to the foregoing, she concluded that the factors identified in the O'Kelly case were met, i.e. the allegations were serious, the evidence was strong, and the sanction was likely to, or reasonably likely to be suspension or removal. Then, having concluded that any inconvenience experienced by his patients or any impact on the doctor was outweighed by the need to protect the public, she suspended his registration. Meanwhile, across the water in the UK, Shemarani, a registered nurse, was struck off the register last month. The allegations in that case were more serious in that she was a prominent COVID denier and opposer of vaccines. Two aspects of her speech were noteworthy. Number one, she made a number of extremely derogatory comments about healthcare professionals and the NHS. Secondly, she regularly referred to her status as a registered nurse in order to support her claims. And the NMC panel reached the same conclusion as Ms. Justice Irvine insofar as it concluded that her beliefs regarding COVID could not give rise to a finding of misconduct against her. However, the panel concluded that the communication of those beliefs, and in particular, the way that those beliefs were communicated, amounted to misconduct. Having said that, the panel made it clear that it was of the view that Ms. Shemarani's views were based on her own distorted version of the truth, and that she was using conspiracy theories to sway public opinion against following official health advice, thereby putting the public at significant risk of harm during the pandemic. In determining that strike-off was the appropriate sanction, it was satisfied that she had deep-seated attitudinal issues, and on that basis, she was highly likely to repeat her misconduct. While the Waters and Shemarani cases have arisen in the context of the pandemic, they are, of course, firmly grounded in the line of case law going all the way back to Allinson and the General Council of Medical Education and Registration in the late 1800s. You may recall that Allinson found himself before that council on foot of numerous advertisements wherein the court concluded that he had endeavoured to defame his brother practitioners. As in the more modern cases, the right to hold particular views was recognised in both the applicable standards and by the Court of Appeal. Lord Justice Davies said the question was not whether he was right or wrong, and he noted he may be right, notwithstanding his differences from the majority. And so it goes, that the right of a healthcare practitioner to hold unusual or unpopular views has been protected since the dawn of professional regulatory law. And where findings of misconduct have been made, those findings have been based on the communication of those views, and particularly the way the message has been communicated. However, it is also clear from the recent cases that we have discussed today that inherent value judgments have been made by the relevant decision maker, which are based on science. And in this era of fake news that we are living in, the challenge for regulators, in my view, is not to silence healthcare professionals who wish to raise a genuine concern, and not to stifle debate, whilst ensuring that the public are protected from both unscrupulous practitioners and those who promote theories, including in good faith, which are based on questionable science. Thank you for your attention. I'm not sure, am I passing over to Maurice or back to Kate?
I think we're passing back to Kate. Thank you very much, Louise. I think Kate's sound situation might have improved. So thank you, Kate, and thank you, Louise.
Thanks, Catherine. Yeah, apologies for the technical difficulties. I'll just restart the slides and go from there. 1 second. Yeah, so as I was saying, before the unfortunately technical issues interrupted, another key case in Ireland is the case of Law Society and Maloko. And this case demonstrates the approach taken by the courts in Ireland to a provision of the European Convention of Human Rights that reflects the rule against double jeopardy. This rule is set out in Article 4 of Protocol 7 and sets out that no one shall be liable to be tried or punished again in criminal proceedings under the jurisdiction of the same state for an offence for which he has already been finally acquitted or convicted in accordance with the law and penal procedure of that state. That case related to a solicitor, Mr. Maloko, who was convicted in the Circuit Court on 6 counts of dishonesty in his practice as a solicitor, and he was subsequently struck off by the Law Society. He appealed to the Supreme Court in relation to the refusal of the President of the High Court to prevent the Law Society striking him off the roll of the solicitors on the basis that to allow the strike-off would violate the rule against double jeopardy. He also claimed that there was a breach of Article 4 of Protocol 7 of the European Convention of Human Rights. The Supreme Court dismissed the appeal and rejected his argument in relation to the European Convention of Human Rights on the basis that Article 4 of Protocol 7 is confined to criminal proceedings. This finding was consistent with a number of European Court of Human Rights decisions in which it was held that disciplinary proceedings were not criminal proceedings and therefore fell outside the ambit of Article 4 of Protocol 7. Moving on then to the approach in England and Wales. The approach in England and Wales suggests that the allegations can be very similar, if not identical, to those the registrant has been acquitted of. However, there has been emphasis placed on the different standard of proof to criminal proceedings. So I suppose in England and Wales, for most disciplinary proceedings, the standard of proof is on the balance of probabilities, whereas in criminal proceedings, it's beyond a reasonable doubt. Whereas in Ireland, the standard of proof for both the disciplinary and regulatory proceedings is beyond a reasonable doubt, the higher standard of proof. And a key case in England and Wales demonstrating this approach is the case of Bhatt and the General Medical Council, which related to a High Court appeal brought by Dr. Bhatt relating to findings of sexual motivation made against him by the Fitness to Practice panel of the General Medical Council. By way of background, this related to Dr. Bhatt, who was tried in the Crown Court on 7 counts alleging unlawful sexual interference with the same-sex patient involved in the regulatory hearing. Charges of sexual motivation were allowed to stand despite the fact that Dr. Bhatt had been acquitted of unlawful sexual interference. However, the difference in approach here may be attributed to the lower standard of proof in disciplinary proceedings. In that case, Mr. Justice Langstaff in the High Court of England and Wales emphasised the differing standard of proof in criminal versus regulatory proceedings. And in particular, he set out that it does not constitute an abuse given that the purpose of disciplinary proceedings, regulation to maintain proper standards in the profession in the best interest of the public and the profession, is different from that served by the criminal courts, and that the standard of proof is significantly different, such that there is no inconsistency between acquittal by jury and a finding by a disciplinary panel that allegations are proved. Another key case in England and Wales is the case of Ashraf and the General Dental Council. And this case demonstrates that it is ultimately within the discretion of the regulator whether to take action against a registrant who has been acquitted of a crime. The allegations against Mr. Ashraf concerned inappropriate and dishonest claims made in respect of payments from the NHS over a 2-year period. Mr. Ashraf had been prosecuted on an indictment concerning 3 counts of fraud and theft in relation to the same NHS claims he had been acquitted of by the jury, and he had been acquitted by the jury on all counts. He appealed to the High Courts on the basis that it was unfair to pursue misconduct charges against him where he had been acquitted of substantially the same charges by a jury on all counts. However, his appeal failed, and the court emphasised that it's ultimately within the discretion of the regulator in these matters. And the court also emphasised that the regulator must act fairly. So the judgment in that case set out that it is not inherently unfair to bring misconduct charges against a professional who has already been acquitted in the criminal courts. This does not mean that there will not be circumstances in which it may well be unfair to proceed. Allegations of crime, which if leading to a conviction would justify erasure, may in some circumstances not justify further investigation by a regulator. And moving on now to the case of Dr. Van Eden and the Medical Council. By way of background, this case relates to charges brought by the Health Products Regulatory Authority against Dr. Van Eden in 2014, relating to the alleged unauthorized importation of medicines from Bangladesh in 2012 in contravention of a specific statutory code regulating medicinal products within the state. Dr. Van Eden was cleared in 2014 after all the charges against him were struck out by the district court. And then arising out of the same matter, Dr. Van Eden is now facing a fitness to practice hearing to determine if he engaged in conduct constituting professional misconduct or poor professional performance. Dr. Van Eden initially challenged the fitness to practice proceedings by bringing judicial review challenge in 2017 when he sought leave to apply for an order of prohibition for preventing the Fitness to Practice Committee from proceeding to hear the matters alleged against him. In that case, he argued that the dissenting judgment of Justice Hardiman in the case of DPP and JC impacted on the decision relating to double jeopardy in AA and the Medical Council, and that the test in relation to the rule against double jeopardy had been altered by that judgment. The case failed on the basis that a decision had not yet been made by the Fitness to Practice Committee, which was capable of review. However, it was held that Dr. Van Eden had not demonstrated how the case of DPP and JC had impacted on the principles in relation to the rule against double jeopardy as set out in AA and the Medical Council. More recently, Dr. Van Eden is now challenging the constitutionality of provisions of the 2007 Act. He seeks a declaration that Part 8 of the 2007 Act when applied to doctors against whom criminal allegations, and that it also infringes the European Convention on Human Rights. He also seeks a declaration that the fitness to practice inquiry after his acquittal before a criminal court is a form of discrimination outlawed by the Constitution. It is unclear whether he seeks to rely on the concept of double jeopardy or whether he is now solely relying on the discrimination ground. The hearing began on the 9th of June last and continues on the 27th of July, so we have yet to see whether this case will have any impact on the rule against double jeopardy in the context of disciplinary proceedings. So I suppose the key points to be aware of in relation to the rule against double jeopardy in the context of disciplinary proceedings is that ultimately the rule against double jeopardy and the doctrine of res judicata do not apply to regulatory inquiries which are held following a registrant's acquittal on criminal charges. As we have seen from the case law in both Ireland and England and Wales, the purpose of such an inquiry differs fundamentally from the criminal process. In determining whether to proceed with disciplinary proceedings following an acquittal, the focus for the regulator is on what is in the public interest and how best to protect the public. Registrants may be acquitted for a variety of reasons, and it does not necessarily mean that the complaint does not constitute professional misconduct or poor professional performance. However, due to the judgment of Mr. Justice O'Keefe in AA and the Medical Council, care may need to be taken in drafting the allegations following an acquittal to ensure that they're not the exact same as the charges that the registrant was acquitted of in the criminal proceedings. And as I said, we await to see whether the decision in Van Eden and the Medical Council will have any impact on the approach to be taken by regulators in relation to disciplinary proceedings following an acquittal. That concludes my presentation, so I'll hand you over to Maurice Osborne.
Thanks a lot, Kate, and thanks for a very interesting presentation. Unfortunately, you can't legislate for technology. So thanks everyone for joining in this morning and for tuning into the podcast. Just before starting, I'd like to thank Mason Hayes and Curran for hosting today's event, and to Catherine, Kate and Sinead for their efforts in preparing today's events. So as Catherine said, paper will be circulated in due course, which will be of some assistance to you. You can to look back on after my presentation. So just by way of introduction, I'll consider the changes to the fitness to practice process introduced by the Regulated Professions Health and Social Care Amendment Act 2020. And I'll consider in the brief 15 minutes I have just some of the changes at investigation stage and inquiry stage, but also some of the changes in relation to sanctions. So as a lot of you will be aware, this bill was put forward by the government in 2019. It was signed off on last year, but arising out of COVID-19 and certain delays, a lot of the provisions are not actually yet in operation. So I thought it might be worth considering some of these provisions and the potential consequences they may have as regards operations in regulatory bodies, and whether any of the amendments are subject to appeal to the High Court. So I'm firstly going to look at the investigation of complaints at the preliminary stage. So there's a significant change in this respect relating to registrants of the Medical Council and the NMBI, or the Nursing and Midwifery Board of Ireland. So there'll be an amendment arising out of the 2020 Act to Section 58(1) of the Medical Practitioners Act 2007 and Section 56 of the Nurses and Midwives Act 2011. So the significant change is that the CEO will take over from the Preliminary Proceedings Committee in the processing and investigating of complaints. The CEO will appoint what will be known as the authorised officer, and this is, I suppose, the most important part, is the appointment of the authorised officer. The authorised officer will investigate the complaint and prepare a report on the complaint. And I suppose most significantly are the powers that the authorised officer will have. So as regards their inspection, they'll be able to compel the production of documentation, records and information which are relevant to the subject matter of the complaint. So that's obviously a very significant power they will have. As regards the terminology in the Act in relation to the authorised officer's powers, they are like for like. So the same terminology is used in the Medical Practitioners Act 2007 as in the Nurses and Midwives Act 2011. And it states that the authorised officer will investigate complaints and assist the Chief Executive Officer and the Preliminary Proceedings Committee in relation to complaints for such period and subject to such terms as the Chief Executive Officer may determine. It also states that the CEO shall specify the functions to be performed by authorised officers. So as you'll probably see, there are very broadly worded provisions, I would say, and in this respect, the powers of the authorised officers will be quite significant. Now, it should be noted that the decision on whether to refer the complaint to inquiry will still remain the responsibility of the Preliminary Proceedings Committee, or the PPC. So that should be noted, but obviously as regards the investigation itself, the authorised officer will have significant roles. So just perhaps to analyse that piece of legislation, I would say that it brings more of an objective and independent approach to the investigation process. And I suppose I was thinking to myself, it's akin to a workplace investigation in an employment law context, where in the ideal scenario, the investigator is entirely impartial. And I suppose that is an effect of this legislation, that the authorised officer will be independent and will be able to look over the complaint from an entirely objective perspective. And I'd say this is a very positive development in terms of fair procedures and due process. But secondly, what I'd say is possibly the most interesting aspect is to consider how the role of the authorised officer will be in the context of will be analysed in the context of previous decisions of the High Court, where the role of the PPC was considered. So the applicable High Court decisions on that matter is probably the BM and Fitness to Practice Committee of the Medical Council, and I'll give a citation to that in my paper. But that decision of Mr. Justice Meenan from 2019, I gather it's from, that analysed the role of the PPC. So, and also the case of Podaryu, which I struggle to announce, and the Veterinary Council of Ireland. And those two cases, I suppose, consider the role of the PPC in the investigation of complaints. And what will be interesting to see is how the role of the authorised officer will be interpreted in the context of that case law. Secondly, I want to consider the provision which will provide that registrants at the preliminary stage will be able to agree to undertakings and consents, and it will lead to the disposal of complaints against them at an earlier stage. So this provision again will be applicable to the Medical Council and the NMBI, or the Nursing and Midwifery Board. So the amendments are to Section 59A of the Medical Practitioners Act 2007 and Section 57A of the Nursing and Midwives Act 2011. So as all of you are probably aware, at present, undertakings can only be requested by committees of inquiry or at inquiry stage. And under the new proposals under the 2020 Act, the PPC, or the Preliminary Proceedings Committee, can request medical practitioners, so under the 2007 Act, to A, if appropriate, undertake not to repeat the conduct the subject of the complaint, B, undertake to be referred to a professional competence scheme and to undertake any requirements relating to the improvement of the practitioner's competence and performance which may be imposed, C, consent to undergoing medical treatment, or D, consent to being censured by the council. Now, the provisions in the Nurses Act, the 2011 Act, are pretty much the same, but interestingly, a broader provision has been included, which states that the PPC will be able to request that the registrant take such steps as may be specified by the board. So that is obviously a broader provision, and so it'll be interesting to see how that provision is applied before the Nursing and Midwifery Board of Ireland. So if the registrant agrees to the undertakings or consents, the investigation is deemed completed and not referred to the Fitness to Practice Committee. An outline, so a report, the PPC will provide an outline of the nature of the complaint and the nature of the undertakings or consents that the registrant agreed to, and obviously a breach of an undertaking will be a ground for a complaint against the registrant. So just from a practical perspective, there's obviously a lot of advantages to this provision. It disposes of matters at an early stage, which is obviously easier for registrants and saves resources for both the Medical Council and the Nursing and the Nursing and Midwifery Board. So it's a positive development in that respect. I suppose I might say it's potentially bad news for lawyers, as the undertakings will not have to be heard before the have to be heard at inquiry stage. So there might be a little less work in that respect. Just to move on to some provisions as regards sanction stage now, and I think one of the most interesting aspects of this of the Act is the appeals of minor sanctions to the High Court. So under the 2020 Act, registrants will be able to appeal minor sanctions to the High Court, which is a significant change. And this provision will be applicable to registrants of all 5 health and social care bodies, so the Dental Council, CORU, the Pharmaceutical Society, the Medical Council, and the Nursing Board. So to take an example of the Medical Council, as I'm sure many of you are aware, when an adverse finding is made against a registrant, there is an obligation to impose a sanction. But up to now, the registrant could only appeal more serious sanctions such as conditions, censure, and erasure. So under the 2020 Act, less serious sanctions such as advice, admonishment, and censure, or what are colloquially more known as minor sanctions, they can be appealed to the High Court. So these appeals will have to be brought within 21 days. And if the registrant does not appeal, another significant provision is that the minor sanction will have to be confirmed by the High Court. And this is in a similar provision to Section 76 of the Medical Practitioners Act, which obviously provided that with more serious sanctions, the order had to be confirmed by the High Court. So it's a very interesting development in that respect. So just to consider that provision, I think it definitely highlights certain weaknesses in the previous legislation, particularly in relation to incorporating fair procedures and the right of access to the courts, obviously. So whilst registrants formerly had the right to judicially review decisions of disciplinary bodies on minor sanction, I think the introduction of this legislation is I suppose an acceptance or an acknowledgement that it was an insufficient form of appeal, the option to judicially review minor sanctions. obviously the right of appeal, you could say it's unsurprising that this has been introduced because of the convention jurisprudence and constitutional jurisprudence, obviously, of the right to appeal. And it's obviously very interesting in the context of a number of decisions. So if we go back as far as the case of Re-Solicitors Act 1954, that obviously dealt with solicitor's right to appeal an order to strike off, and obviously M versus the Medical Council, and more recently the Corbally decision. And I'd say this provision was, it goes so far to say that it was almost essential in the context of the Corbally decision, where the lack of a right of appeal in minor sanctions was highlighted by the late Mr. Justice Hardiman, and obviously the serious implications for a medical practitioner or a nurse, the serious implications that a minor sanction could have on their reputation and their ability to earn a livelihood. So lastly, I'm just going to consider sanctions in relation to the publication of findings. So the general rule is that regulatory bodies will publish sanctions where it is in the public interest. This changes under the 2020 Act. So all sanctions will now be published, and this will be applicable to the Dental Council, the Medical Council, the NMBI, CORU, and the Pharmaceutical Society. So all regulatory bodies. Also, sanction imposed by regulatory bodies in other jurisdictions will be published if it is deemed to be in the public interest. So that's another very interesting development. Further, the Fitness Practice Committee will be able to order info in relation to the complaint to be published and it's not to be published, and it makes an offence if this information is published. In addition, there's a provision providing for the publication of findings in an anonymized fashion. That's a very interesting provision, and I thought I might consider a case of Mr. Justice O'Moore from last November. That's the medical accountant and a medical practitioner. And in that case, Mr. Justice O'Moore made reference to application. It dealt with Section 76 application, but Mr. Justice, or the former president of the High Court, Peter Kelly, stated that applications for Section 76 matters to be heard in public must be approached with resolute skepticism. So I suppose this is an interesting piece of legislation in that it will provide for the publication of findings in an anonymized fashion, something which wasn't provided for previously in the legislation. So just to conclude shortly, those are just some of the provisions that the 2020 Act has provided for. It's obviously a fairly expansive piece of legislation, and it's introduced changes as regarding the registration of medical practitioners also. So I've expanded on these points in my paper, and lastly, it'll be interesting to see how these new provisions are whether they're subject to challenge before the High Court, and how they operate in the context of hearings before professional bodies. So thank you very much for your time and for listening to me, and I'll hand back over to Catherine now.
Thank you very much, Maurice, and thanks to all our speakers for their very interesting presentations. As you might expect, we have some questions arising out of them. Maurice, if I could stay with you for a moment, some questions around undertakings. There's a question here, perhaps by a lawyer concerned about lack of work due to undertakings. Will undertakings given to the relevant body have to be confirmed by the High Court?
No, the matter, unfortunately, the matter will deem to have been concluded. So no, so it's unfortunately there'll be a significant reduction in work in that respect. So no, it's concluded at that stage, and obviously there's, as I was saying, significant advantages for the relevant bodies and for registrants. But unfortunately, from a lawyer's perspective, the matter will be deemed to have concluded at that point.
Very good. Yeah, well, obviously a great advantage for the regulators concerned. Staying with undertakings, Maurice, would a registrant be able to appeal an undertaking or consent to the High Court, or is the undertaking the absolute conclusion of everything and nothing further can arise?
So, no, there isn't, but the registrant will not be able to appeal the undertaking. But I suppose what an interesting issue that could be raised in that respect is perhaps whether a registrant has received legal advice in the context of an undertaking. So obviously the issue has been taken out of their hands if they agree to the undertaking, and it'll be interesting to see whether, I suppose, the seriousness of the complaints that are brought against registrants, whether the undertakings are potentially subject to challenge, but it's provided for in the legislation they will not be. But I suppose the issue of legal advice could be quite interesting in that respect down the line.
Okay, great. Well, thanks very much, Maurice. Louise, there's a couple of questions I think arising out of your presentation. Aside from cases involving COVID denial and opposition to vaccines, what other types of issues have been giving rise to complaints during the pandemic? Do you know?
Well, according to the Medical Protection Society, or the MPS, there have been a couple of common themes emerging. One of those was expected, and that's delay in relation to cancer diagnosis. And insofar as I understand matters, that's always been a common theme, or something, a real risk in terms of complaints. Other issues that weren't anticipated, and I think we can all identify with if we're sick of remote working, is communication issues arising from limited face-to-face consultations, and also the phenomenon of COVID blindness, which was a jumping to assuming that the patient had COVID. Interestingly, issues that were anticipated and that practitioners were really anxious about, specifically because they were working outside their normal area of practice, haven't particularly emerged as common themes for complaints, but as we know, there's no statute of limitations on complaints to our regulator.
Okay, so there may be developments there over time. Just going back to the Waters case, was there any discussion of undertakings in that case? There seems to be a theme of undertakings here in the questions, really.
Well, yeah, exactly, Catherine, as you'd expect, you know, in these types of applications, the order is only made when it's absolutely necessary to protect the community. And there's actually a very detailed critique of the undertakings that the doctor offered in that case. And I deal with these all in my paper, which is very detailed. But it's a very useful judgment for practitioners who may find themselves proposing undertakings or assessing undertakings, because Ms. Justice Irvine identifies specific problems with the lack of specificity, the vagueness of the undertakings, what isn't offered, but you know, all of those are issues you can get over if you draft your undertakings well. But what couldn't be gotten over in this case was the undertakings couldn't be supervised because he was a sole practitioner, and moreover, there was the concern, you know, particularly with his undertaking not to give misleading information. What would be misleading to him in that he considered COVID a hoax? Very interesting.
Yeah, very interesting. Thanks, Louise. Kate, moving away from undertakings, so you discussed in detail, obviously, what is the position where the registrant was acquitted of an offence. How does that position differ where a registrant has in fact been convicted of an offence?
Yeah, no, as I was saying, where the registrant has been acquitted, the matter can still be referred on the ground of professional misconduct or poor professional performance. However, in circumstances where the registrant has been convicted of an offence, the regulator may refer the matter to inquiry on the grounds of a criminal conviction, where the conviction is triable on indictment. Or if it's a conviction from outside of the state, it must have been an offence consisting of acts or omissions that, if done or made in the state, would constitute an offence triable on indictment. And that's set out, that's a provision in the Medical Practitioners Act and the Nursing Midwives Act 2011, and it's also in the Pharmacy Act and the Health and Social Care Professionals Act. So otherwise, I suppose the matter can still be referred on the grounds of professional misconduct on both the conviction ground and the misconduct ground. If it's not, I suppose if it's not a conviction triable on indictment, it can still be referred forward on the misconduct ground. So that's, I suppose that's the kind of main difference.
And are there things that the regulator should be aware of if pursuing a fitness to practice case on the basis of a conviction?
Yeah, no, there would be a few things that the regulator should be aware of in relation to pursuing a fitness to practice case on the basis of a conviction. I suppose importantly, in terms of proving the allegations, to prove the conviction allegation, it'll be necessary to obtain the certificate of conviction. But in order to prove a misconduct allegation, while the conviction or the certificate of conviction is strong evidence of the conduct that has given rise to the conviction, some further evidence may be presented depending on the stance adopted by the registrant in relation to that conviction. So the evidence can go to proving the misconduct as well as providing context for any sanction recommendation arising from the findings. But if it is just the conviction ground, then the certificate of conviction should suffice. And I suppose another thing to be aware of is in terms of framing allegations. There's an important distinction to be made between conviction and misconduct allegations. So for conviction allegations, the allegation can be framed in terms of the conviction. So it should set out that on a specific date, you were convicted of the offence. Whereas misconduct allegations should set out the details of the offence. So it should set out on the date in question, you did, for example, you did assault a patient in your care. So I suppose those are just a few factors that the regulator should be aware of in relation to the conviction or allegations following a conviction.
Okay. Thanks very much, Kate. Well, we're coming up to 12 o'clock, so I just want to thank all our speakers again, Kate, Louise and Maurice, for their very interesting presentations, and thank you also to the Professional Regulatory and Disciplinary Bar Association, who are co-hosts this morning. And finally, thank you to all of you for participating and for your questions. Just to say that a feedback survey will automatically appear on screen once the webinar ends, and we'd really appreciate it if you could fill that out, because it really helps us plan our next webinars. And that brings our webinar to a close. So thank you, everyone. Bye-bye.
Thank you.
Thank you.